He was a federal prosecutor. Now he works the defense side of the table. David Katz, everybody.
Great to be with you.
Hello, sir. Yeah, really good to be with you. You know, I was just doing a story about the fact that the Supreme Court has changed as a result of those obstruction charges that were then challenged at the Supreme Court level. They've kind of pared back the ways in which you can use obstruction charges, obstructing an official proceeding is what I'm talking about. They pared that back, and we just had a story about how they've actually now dropped charges against yet another. This is a former police officer who was there at J6. They're still bringing charges, but they're dropping the obstruction charges, David.
Well, there's a 5-year statute of limitations, so the 5 years hasn't run yet. So people are still subject to prosecution. And so I think that although that charge may not stick, that was a little over expansive because it was passed over the Enron scandal and had to do a lot more with destruction of records, let's say by an accountant or someone who was subpoenaed, and the records disappeared. It wasn't really directed at this kinds of records destruction where you're really marauding, you're trespassing, you're attacking officers. So if they don't have anything other than the destruction of records, then yes, that particular charge against that particular person would have to be dismissed. But I think they'll rarely, Mark, find themselves in this situation, especially since it'll be timely to bring new charges. So if someone was only charged with obstruction and it's just about that, let's say they were charged on that count, Mark, but they also trespassed, they also wrangled with some officer inside, they'll be charged with the trespassing and the wrangling with the officer. And kind of, good motion, defense attorney. You got that one dismissed, and maybe you got your client hit with 2 new ones.
Now to this superseding indictment that came down this week. This is Jack Smith reanimating, essentially, the Trump indictment. Can you speak to this? I was saying, I think yesterday, it's a slimmed down indictment. Certainly in terms of the paperwork, it's slimmed down, but it's also slimmed down in terms of the actual charges.
Well, normally, again, to see it from the point of view of a criminal defense attorney, you don't want to see a superseding indictment. That means that new people have been added who may be cooperating against your client, or that your client has been hit with additional charges, superseding charges. This is a slimmed down superseding indictment. That's, of course, very rare, but of course, it's what's called for here, because the U.S. Supreme Court made clear that anything that smacked of an official act had a presumption that it was covered by presidential immunity. So there's kind of 3 kinds of acts people will recall from that bombshell, very controversial U.S. Supreme Court decision. One, there are core presidential acts, appointing an ambassador, vetoing a bill, conferring with a foreign head of state. Those were all things that Trump did in ways that, if he were not the president, might have been indictable, right? He might have traded a pardon or some other favor in exchange for an ambassadorship. He might have said something that was actually treasonous to some foreign leader. But all of that, that's all impeachable. He could have been removed if the Republicans in the Senate had voted to convict him after January 6th in the Senate. He would have been not only removed at the very end of his term, but he would have been disqualified from running again. And maybe the Republicans could have started over with some other candidate. He wouldn't have had this cachet. He wouldn't have still been in the game, Trump. But we are where we are. So he was not found guilty by the Senate. So those are impeachable offenses. And people will recall that Senate leader McConnell had said on the floor of the Senate, oh, well, yes, we're not impeaching him, convicting him here in the Senate, but of course he's indictable. He's always chargeable for this conduct. Well, turns out that he was not chargeable for much of that conduct because it's core stuff. Now, then there's completely private stuff. He always gave the example, Trump, I could shoot somebody on Fifth Avenue and nothing would happen to me. Not true. If he shot somebody on Fifth Avenue, that would be a private act. That would be a non-official act. But of course, the rub comes with the ones in the middle, Mark, and those are the ones that are presumptively presidential immunity. And the key one here is the one with Pence. The U.S. Supreme Court even used the example with Pence, and they said, boy, that sure sounds like one that would be either a core responsibility or certainly presumptively presidential immunity when the president speaks to the vice president. And a lot of people thought that the special prosecutor would back off that one and not have a big fight. And, kudos to Jack Smith, because he said, you know what? No, bring it. Bring your appeal to the U.S. Supreme Court. Bring your interlocutory appeal. I know you're going to the Supreme Court against Trump, but I'm willing to fight on this hill. And the hill is that that Pence is the president of the Senate. He's number one, another branch of government. And they want to see him not as president and vice president, but as some candidate who couldn't give up the fight, some candidate, Trump, who went to another branch of the government, the head of the Senate, and said, do all of these crooked things, and they're indictable. And they're going to fight over that. And so one thing that's very interesting is, are they going to have an evidentiary hearing? Are they going to call Pence to the stand before the election in front of Judge Chutkan? People think that's the real power card here for Jack Smith. If he doesn't want to just play Mr. Nice Guy all the time and actually do something which is both proper and would be effective, say, look, the U.S. Supreme Court said the district judge is supposed to do fact-finding. Fact-finding is not just filing briefs. Fact-finding is calling witnesses and subjecting them to direct and cross-examination. And our first witness is, let's say, Mike Pence. And our second witness at this evidentiary hearing is, let's say, Casey Hutchinson, and some other people who would be very sympathetic to Jack Smith's case, and showing that these were, in fact, call some of these people with the slates, call some of the other people with the corrupt stuff. And so the idea would be people who think that all the electoral impact of it will go to after the election, because nothing will happen before the election. There'll be no trial before the election. And it's absolutely clear there'll never be a trial of this case, or the Mar-a-Lago case, by the way, before the election. But there could be this evidentiary hearing. So it couldn't be like, well, Trump just got away from having any influence on anybody. And it's relevant, Mark. It's relevant to have that evidentiary hearing. Having said that, people think that Jack Smith may not want to push that far. Probably Trump would try to go to the appellate courts and try to get that hearing, if ordered by Judge Chutkan, stayed or delayed, or it's so unfair, or it's this, or it's that. I believe the U.S. Supreme Court would back off of that one. I think they would not stop an evidentiary hearing from taking place after the U.S. Supreme Court itself said there's supposed to be fact-finding.
You anticipated my question, which was associated with timing, because now the clock is really almost striking midnight. And can you just tell me, as a practical consideration, what can actually happen between now and Election Day? And then as a legal consideration, what can actually happen between now and Election Day?
8 days from now, the parties are supposed to tell Judge Chutkan how they want to proceed. That would be number one, what kind of briefing schedule they want. And then as part of the briefs, I mean, you can't have an evidentiary hearing just out of space. They'd have to say, excuse me, motion to find that the conversations with Pence were not presumptively presidential immunity. They were not within that. This is our effort to rebut that presumption. So motion to rebut the presumption that the Trump-Pence communications were covered by presidential immunity.
In other words, and just to be clear about it, a motion to argue against those being protected communications.
Right. And so
Okay.
Jack Smith would file that soon. He would tell the court on Friday that he wants to have an evidentiary hearing. He wants to bring that motion. The Trump attorneys would yell and scream and say that that was out of bounds, this and that. It was all a big election interference. It was all a big carnival. He would reply and say, the U.S. Supreme Court said there was supposed to be fact-finding. There are things that Pence would say that are relevant. One thing that's good is that, Pence is not now a devoted Trumpster. So if he were a devoted Trumpster, you can imagine how, watch out for what you ask for, Mark. You might get it. You don't want to call somebody who's still, true blue. You don't want to call Boris Epstein to the stand and have him testify about what he recalls of that conversation of Trump and Pence. I think the only thing that really makes sense is you call Pence to the stand, but I think Pence would be cooperative. He didn't support Trump. I think that he would tell the truth. And then you would elicit from that things that showed it was not a core function. It was not covered by presidential immunity. And that would depend on a lot of, the particulars of it. But the basic way that they've characterized Trump now is not as a president acting in his official functions, but as a candidate who was just trying to get this scam of his to take effect. And if he were the opposing candidate, let's assume for a second that Biden, who was not in office, had done those things, right? That Biden had made those communications with the head of the Senate. You know, he's an old friend of Pence's, so he tried to persuade Pence to come out Biden's way by doing corrupt things. Why on earth wouldn't Biden have been indictable for that conduct? They've tried to, speaking at the Ellipse, Biden could have been speaking that same day about, go into the Capitol and make sure that they do certify the election, right? Go on the Capitol. So they want to treat Trump not as a president, because they have to not treat him as a president doing official acts under the U.S. Supreme Court ruling, which, by the way, I totally disagree with. Can I mention one other thing? The justice appointed by Biden and approved by the Senate, Jackson, she held an interview on CBS. And, one thing that I was thinking about was everyone talks about the Supreme Court has to have these rules of conduct. It's so hard to get these rules of conduct. Probably one of the rules of conduct would be that you're not supposed to have press conferences if you're a sitting U.S. Supreme Court justice. Well, guess what? There's no code of conduct. So by the same token that Thomas can do all of these, things that just blow your mind. And I don't know if Jackson or Sotomayor or the other Democratic justice, whether they really have the stomach, whether they have the grit for this, whether this is their kind of thing. But without talking about U.S. Supreme Court deliberations, they could do a lot more than read their dissents from the bench of the U.S. Supreme Court. They could be on television all the time saying this is an outrage what the rest of the U.S. Supreme Court members did. And there could be actually commentary, not just on like this one interview she did on CBS, but this could become a thing. And there's no reason why. Of course, other people can do that too. But without a code of ethics that binds them like other federal judges, right? What she did was totally proper, and she could make a habit of it this next term. And when they cut back these environmental protections and so forth, cut back the Chevron doctrine, do those kinds of things, there's no reason why U.S. Supreme Court justices couldn't do that. That, of course, if they start doing it, that might sell the Republicans on having a code of conduct, which would include them not holding these press conferences, which could be especially embarrassing to the 5 or 6, who are just intransigent on the U.S. Supreme Court, who just want to change old precedents. The case that they had, whether people who have under domestic violence injunctions had a Second Amendment right to have a gun anyway. I mean, some of the things they've done on the U.S. Supreme Court besides Dobbs, you just smack your head.
Sure. I mean, the fix is in. I mean, there's just no, there's no legal wrangling logically. There's no pretzel logic to get to a lot of these decisions that they've come up with based on what you've told us and all of the stuff that I've read from other legal scholars. But it's interesting what you've suggested, because just to digress with that for a second, you're right. We grew up with the Supreme Court sort of in total silence. The dissent was something they wrote. It wasn't something, it was in the same way that the decisions were written, the dissenting opinions were written as well. But now, in the new media age, to have Ketanji Jackson come out and speak to the cameras, it's a different kind of world. And yeah, look, this is insane what's happening at the Supreme Court level, and I would hope that they can come up with some sort of code of conduct. But I would also hope that they could expand the court. I'd also hope that any number of things could happen that probably will not. But certainly the code of conduct is something that's probably a closer eventuality than is the expansion of the court. Right, David?
Well, all that they would need is to have, Harris win, hold the Senate, and have a bare majority. And then the senators could say, you know what, you've now added justices to the U.S. Supreme Court by a 51-49 vote. There's no reason that we can't take this out of the filibuster. You packed the court, you Republicans, over 20 or 30 years with these right-wing ideologues. And you've done that on a mere majority. And we can cure that problem by a mere majority. The filibuster is not going to apply to this bill to expand the number of justices on the U.S. Supreme Court up to 11 or 13. And people say, well, if the Republicans ever had the whole table again, if they had the presidency in both houses of Congress, well, they could increase it to 15 or increase it to 17. But you know what? Worrying about that eventuality happening, if they had both houses of Congress, the Democrats, and if they had the presidency, I mean, it's not going to be me 30 years from now. But some of your listeners are going to be living in a world 30 years from now where Kavanaugh, Gorsuch, Barrett are still on the U.S. Supreme Court. And with a couple of picks, they'll still be controlling the Supreme Court and eviscerating these environmental regulations. Anybody who cares about the planet needs to care about the fact that these 9 are going to go out of their way to strike down laws that help us do something about this poor planet. And what's happening to it, and many other regulations, regulation by regulation, something as small as this regulation that they just set aside. They refuse to let President Biden do anything about relieving some student debt. It's just unbelievable. They just refuse to let this new regulation of Biden's go into effect that would ease some student debt. It apparently is not as big as the old student debt relief. It does something with the calculation and calculates it in favor of the student debtors. That was too much for this U.S. Supreme Court. So the bill that they're talking about is good, the Democrats, because it raises that issue of the U.S. Supreme Court. It makes people focus back on it, and especially focus on this abomination that is the Dobbs decision overturning the 50-year precedent on a woman's right to choose. But people just have to do something about this situation and focus on it. But term limits is not the right answer. If you think about it, the term limits would only apply, in the hope that Democrats have control and that there are term limits. The Democrats are the one pushing term limits. What it would do if they win, if that's all they get, it would term limit their appointments. It wouldn't term out Gorsuch, Kavanaugh, Barrett. It wouldn't even term out Alito. It wouldn't apply to any of them. It would only apply to their new picks. So that's not the answer. The answer is absolutely, and it doesn't require a constitutional amendment. There's nothing in the Constitution, Mark, that sets the number of U.S. Supreme Court justices as 9. The great Abraham Lincoln, before he says the great Hannibal Lecter, I think sometimes Trump says the great Abraham Lincoln. The great Abraham Lincoln increased the size of the U.S. Supreme Court from 9 to 10, and the country survived. We survived the Civil War, and we survived barely. And not if you take into account Jim Crow and stuff like that. A lot of people really didn't survive for generations, the outcome of the Civil War, without having Reconstruction done vigorously. But certainly the court survived going from 9 to 10, Mark. And the fact that FDR gave a, quote, court packing a bad name, that was not thought through at all. It was way too complicated. And as they say, a switch in time saved 9. It turned out that one of the justices voted with the FDR New Deal programs. He had voted against those programs before, the famous saying, a switch in time saved 9. So if you're waiting for Alito and Thomas to switch and suddenly understand that precedent means precedent, don't wait for that. Don't wait for that. Expand the size of the U.S. Supreme Court to 11 or 13. Have some really moderate justices put on there. That would be good to decrease the polarization. Just some super well-respected legal scholars, judges, best thing, probably appellate judges, moderate to liberal Democratic appointments. Of course, that's what they would be. But you might have a Republican in there. That might be another thing.
The Democrats are more likely to put a Republican and somebody who's reasonably middle of the road in there than the.
There are some wonderful Republican appointed judges throughout this country, including appellate judges. I don't say when I get a case, oh my God, I have this Republican who was appointed by either Bush's dad or Bush. That's usually who they are. Of course, there are some Trump ones too, but I just tended not to be in front of them because I've had more appeals in years past than I do currently. But the fact that someone was, we had judges in those days from Nixon, from Ford, appellate judges, Bush's, and at least on criminal defense issues, they tended to be more conservative than the Democratic appointed judges. They tended to be more pro-business. But it was not the kind of stark thing that people are looking at when they see someone like Gorsuch I mean, you see someone like Gorsuch, you just say, "Oh my God, that Gorsuch got that appointment and not Merrick Garland." Talk about a change
Yeah,
on the
I mean,
U.S.
and Gorsuch is
Huge
there to
thing.
do the work of corporate polluters and for big corporations to be able to ride roughshod over basic consumer protections, over basic environmental protections. As you say, you don't have to care about the planet at large. If you care about clean water, clean air, and pure soil, then you need some voices and opinions on that Supreme Court that go against these guys. This is I think they're like mafia dons for the people that they work for, which and those people apparently are, having bought and paid for these guys, they are big business. And I don't care what he says about, regular stock, but
I come from regular stock.
I mean, the reality is quite the contrary. But I'd like to hear this, particularly from you. You're very fair-minded, and you feel we should. I think one of the things I didn't like about Joe Biden is that he's such an institutionalist. He's so worried about the blowback, on suggesting that you would expand the court. I think. I mean, he didn't state it, but I think that checks his enthusiasm on something that is viewed as so radical when you're an institutionalist. But I mean, the reality is they didn't worry about the blowback when they rolled back Roe. They didn't worry about the blowback when they made these immunity decisions that you and many others didn't think ever would come down to almost literally just help and protect Donald Trump. And I don't think Biden and Democrats, and if they get control of the Senate, and that's a huge if, I understand they have it now, but they very easily could lose it. I don't think they should worry about expanding the court. I wanted to ask you about.
Mark, can I just touch on that very quickly?
Sure.
Some of my favorite justices, just from my own philosophical legal perspective, were Republicans. Stevens, probably one of my favorite justices of all of them. He also was the only one who hadn't gone to the Holy Trinity, Harvard, Yale, Columbia. He was at that time the only one on the U.S. Supreme Court for a long time. Don't look for University of California graduates. We've only had one in a long time, and that was Earl Warren, the great Chief Justice Earl Warren, the Warren Court. One thing that's interesting about Harris is Harris went to the University of California Law School. So, okay, if we can't have a Supreme Court justice, how about a president?
Well, now your partisanship is showing. It's collegiate partisanship.
I also like Souter, and Warren, of course, was a Republican.
I want to get off the Supreme Court for a second and ask you about a bizarre case. There was a case in Texas, in the criminal courthouse, a defense attorney arrested, accused of smuggling drug-laced paper in the guise of power of attorney documents to a defendant in the building. This guy, licensed to practice law in Texas since 2008, he's an attorney, in other words, charged with engaging in organized criminal activity and bringing a prohibited substance into a correctional facility. The scheme came to light during a review of jail calls in which an inmate discussed a potential deal between an attorney and a murder defendant in his cell block, scheduled for days later. Investigators reviewed the attorney visitation logs and determined that this guy visited the defendants in jail after having represented him since 2022, went to court for a bail hearing, was handed documents, and the documents were potentially laced with meth. This happened inside the courtroom, according to the sheriff's office surveillance video. The investigator watched Johnson's movements in the courtroom's gallery, said that he entered a holdover area for inmates with the documents, emerged then without the documents, and so on. I mentioned this to you in email form because I thought it was such an extraordinary thing, and you said, actually, this isn't a situation that you hadn't heard of before.
There was someone in the Central District of California, my federal district here, that got investigated for this. I don't know if he ultimately got convicted or not, that he had brought some kind of drugs into the Metropolitan Detention Center, that white building with this tiny little slits for windows downtown LA. And that's where, I go to see a client if the client is in custody. And of course, you don't need a lawyer to be a lawyer to know that that's a criminal violation by anybody. It's fair to say, though, that the people who commit that crime by far the most are law enforcement, crooked jailers, right? Crooked cops or sheriffs who allow cell phones to go in there, who allow all sorts of things. There's a great scene, and I think it's Goodfellas, where she's bringing in salamis and all that kind of stuff for the Italian mafiosos who are incarcerated there, but they're living this great life up in the loft somewhere where they're having a Italian, beautiful Italian dinner every night, and the girlfriend or the wife is smuggling the stuff in. If you remember the scene from Goodfellas, and obviously someone's getting bribed to allow that to happen. So it's mainly law enforcement, cops, sheriffs. But obviously, if you're a criminal defense attorney and you come up on the surveillance cameras like that, this guy's in a world of trouble. What actually happened with him was, he pled not guilty. He's posting bail. He's being allowed, according to the article, to continue to practice law. They're trying to disqualify him from that particular case where he represents that defendant. It's hard to imagine that he has, much of a defense while everyone's entitled to the presumption of innocence. Normally what happens, Mark, in the courts is that you are not allowed to give a document to somebody. You would be hard pressed in the courts in LA, federal or state, even if you were so inclined to give something like that to your client. You normally have to mail everything to the client, not give it to them by hand. And once you mail it in, of course, it's put through whatever they put it through, puts through detectors to make sure, I guess if the dog starts alerting on your, a service copy to your client, that's real bad. You can imagine somehow that happening. You can imagine someone in some law office who's corrupted and they're sending something like some staff member. It might not be the lawyer, but obviously this lawyer handing it to the client if there's a surveillance thing, and then they go check it out and, it's meth or it's marijuana, especially in Texas. That this lawyer needs a good criminal defense lawyer.
Well, the documents and the papers that they're talking about were discolored, and there was an odor. In other words, it was really not done in the slickest way. It wasn't like an Ocean's 11, Ocean's 12 type setup. Apparently, I want to ask you. Yeah, go ahead.
Agatha Christie wouldn't have written it that way.
No. The last thing, and I suppose this is just pro forma, like this is just stuff that happens. You always ask for this. But the defendants in the Arizona fake elector case, David, they've asked for the case to be dismissed. This is 11 people who signed documents claiming to be Arizona Electoral College electors, even though Joe Biden had won the state and there was certification of that Arizona victory, and those electors were already assigned. These people are being tried. It seems extraordinary that it's taken so long to try them, but I wonder if you can speak to this effort first to have the case dismissed, and now what the timetable is on this case.
Well, the first thing that pops out at people is how on earth could the trial be set in 2026? Aren't we in 2024? Didn't this thing happen back in late 2020? It took a while to bring the case. I think that there was a new attorney general who was elected down there, and the new attorney general decided to pursue the case, and maybe the old attorney general was a Republican who didn't want to pursue the case. I'm not sure that that's the scenario, but it certainly took a while before it got filed. People see that date, even January 2026, and they say, my goodness, how can it take that long? But bearing that in mind, I'm a criminal defense attorney, and I've seen a lot of the problems with discovery, with different motions that are brought. I've seen the reason why these cases do take a long time, Mark, to get to trial. So I didn't have the same reaction that, oh my God, how on earth could this happen? Not even have a trial until January 2026. I'm sure it's pretty complicated. And my understanding is that the prosecutors are not fighting it that hard. They may be recognizing that there's a lot of discovery, there's a lot of different motions. There may be reasons why it can't go until then. In terms of trying to get it dismissed, this one I haven't followed that closely, but this one hits me as one that's a little hard for the prosecution. There's a lot of defendants. You remember the problem down in Atlanta. Once you have a lot of defendants, they have a lot of motions. They want to sever their case from the other defendants' cases. There's a fellow, he's one of, I think, Trump's top legal advisors and lieutenants, this Boris Epstein. I don't think he's been charged anywhere else. It's just hard to believe that a very smart fellow like him really is good for this. I mean, that they really have compelling evidence, Mark, that he said, oh, yes, I know we lost Arizona and that the electors have all been chosen, but let's go send some fake electors. I just think it's going to be very hard to prove this case. Remember, it's not civil. They have to prove it beyond a reasonable doubt as to each and every one of the defendants. Of course, some people like Giuliani are in the case. It's a lot easier to believe that he did a lot of, stupid and criminal things, allegedly, that they could actually prove beyond a reasonable doubt. They have a couple of cooperators in this case. But again, unless there's like emails or things like that against a particular defendant, recordings of a particular defendant, it seems like a hard case. That Jenna Ellis, she's come forward again to be a cooperating witness. I don't know exactly what she's going to say. If she's going to say there was some huge meeting where everyone agreed that even though the vote had been certified and recertified, we were going to fight it anyway, and we were going to send a bunch of phony electors to Washington. And it's a lot of reasons to be suspicious. There's Senator Johnson, remember, from Wisconsin, who hands somebody a package that he's gotten in a Senate mailroom. He's got nothing better to do as a senator than take this package from the Senate mailroom. He wants the guy for Pence to give it to Pence. And it's apparently a list of phony electors. I mean, this whole thing is so crazy. I think Senator Johnson's defense is that he was on the floor of the Senate and that maybe he has a constitutional protection. But it's great that they investigate all that stuff. I think Arizona, Mark, is going to be one of the really hard cases to prove all of those defendants guilty beyond a reasonable doubt.
Well, I just, when you say that there are a lot of moving parts to this case, I'm sure there are, and you said that there are complex parts of this case and that there's so many defendants. I get it that there are, but I would say, gosh, David, I mean, you've just also noted the cake was baked. Then they tried to fake up these electors. There's no question, it wouldn't seem that these people were associated with this. They signed documents. They were in on this caper. I mean, again, isn't there a way to boil this case down to that? The simplicity of wrongdoing here seems to me undeniable.
Well, I think the case may get severed. There may be more than one group. And I think, yes, the prosecutor, and I said this about Atlanta, should decide who they really want. There's a lot of defendants here. Remember in Atlanta, besides the problem that she had with her potential disqualification and the disqualification of the special counsel, remember, we called him the $700,000 man, and he was required to get out as the special prosecutor down there in Atlanta. But there were, besides that problem in Atlanta, Mark, there were an awful lot of defendants. And so I just think that, that's one thing we learned as prosecutors. You can't charge everybody in the case, okay? Use some of them as your witnesses, pare the case down, figure out who are the 3 or 4 people that you really want, focus on them. But just from the number of defendants here, I think it makes sense that it's going to be a long time getting to trial. So I don't mean to minimize it, Mark, and it may have been very well caked in, but these people are also covering their behinds. A lot of them are lawyers. A lot of them are very smart people. And you just kind of wonder if they made these, one of the defenses is that this was a contingent thing. These weren't actually going to be the electors, but suppose Pence disqualified it. He said the Arizona vote was no good. Okay, well then who are the electors? They were going to come in as alternates, and it was understood that they were only going to pinch hit if there was some problem, and that they were not going to be palmed off as being the real electors, and the real electors were going to be, shunted aside and replaced by them. Yeah, that's going to be one of their main defenses. And some of them gave legal opinions about this. And so some are going to say, well, that was my legal opinion. It was in good faith. And the other people are going to say, I wasn't a lawyer. This guy was a lawyer. I relied in good faith on the advice of this lawyer. Eastman, I think, is in this one too, right?
Sure, exactly.
He was a distinguished attorney. I mean, he was the dean of a law school. I mean, he was sort of a distinguished attorney,
Yeah, those were the old days. He's not distinguished anymore. No Contendo says, Jennifer Ellis, state evidence, PC, docs, emails, dead to rights. Sounds like, yeah, I mean, maybe.
That person may know a lot more about the case. I just, there've been
no. Well, what I would say, and the last thing, and then we'll wrap up. But I just go back to the timeline and the clock. I mean, I think that the fact that this can be scheduled for that far down the way, I get it. There are complexities. There's a lot going on. There are many moving parts. But aren't we close to the statute of limitations on this? I mean, it's going to start this again. The trial is scheduled for January 5th, 2026. So it happened in 2020, David. I mean, if it gets to 2027, isn't there? Or as long as
as long as the case is brought timely, it's charged or indicted timely, that tolls or stops the running of the statute of limitations. The interesting legal question is, let's say there is something wrong with the indictment and the indictment gets tossed. And now they want to do a replacement indictment. They want to cure the problem that got the original indictment tossed. That might be untimely. So a criminal defense attorney would always rather have all those motions, right, to be heard after they can't very well be cured by the prosecution, if that's the law down there in Arizona. It's a complicated area. Can I mention one last thing, Mark?
Sure,
kind of
go ahead, sir.
Surprise me sometimes, you and Kim. Can I surprise you a little bit? There was an interesting case regarding former governor, vice presidential candidate Sarah Palin and the New York Times. And I'm a New York Times subscriber. I discount what I read in the Times sometimes, but thank God there's a New York Times. I mean, some of their investigative reporting is just absolutely wonderful. The New York Times has never lost a defamation case on American soil, they say. And they may actually lose this Sarah Palin case. It's possible. Just now, it got remanded for a new trial proceedings by the Second Circuit Court of Appeals. And the reason I mentioned on your show, and I think it's interesting, is a lot of people assume that Judge Cannon down there in the Southern District of Florida will be removed from the case if it gets sent back to the district court. And if you look at this as a precedent, this is a pretty good precedent that Cannon will not be removed, because in that case, the judge's name is Jed Rakoff, very well-known Clinton selected judge. And he made a lot of errors. I mean, he threw the case out the first time. And then the Second Circuit reinstated and said, no, it's a viable claim. You have to take this case to trial. Then the case went to trial, and he made a lot of errors. And including one of his errors was he said that the New York Times basically should be dismissed from the case. And they said, well, wait, at least let the jury finish deliberating. So he said, okay, I'll let the jury finish deliberating. And then you get these notices, these push notifications on your phone. So while the jury was out deliberating who should win the case, Palin or the New York Times, they got their push notifications that the judge had said that the Times ought to win. And then the judge had his law clerk apparently discuss the case with the jurors. And the jurors said, oh, no, getting that push notification, that didn't really affect my verdict. I mean, talk about a not by due process way to try to determine, I mean, where are the lawyers? Where are the arguments? Where's the, interrogation and cross-examination of the jurors as to whether they were affected or not? And the Second Circuit threw their hands up in the air. Palin asked that the case be sent back to a new judge, after that error, after errors in the instructions, after him throwing the case out the first time. This was the second time that he was being reversed by the Second Circuit Court of Appeals. And the Second Circuit Court of Appeals said, no, we're sending it back to the same judge. There's a presumption that all federal judges are going to be fair and act judiciously and properly. So I think that's what's awaiting the Cannon reversal, that it goes right back to Cannon. This case is not direct precedent. It's from the Second Circuit. That case would be from the 11th Circuit. But it illustrates the point that we don't routinely send cases back to a new and different district judge. And I've said for years that I think we ought to. It creates other problems. And the idea is that this Judge Rakoff knows the case very well. And they'll argue that Cannon knows the case really well. But as between those kinds of situations where a judge is not just reversed once, but reversed more than once, repeatedly reversed, as Cannon, I think, will be, and as this judge was, I think we should not have this idea that we just send the case back to the same U.S. district judge. Yes, a U.S. district judge would have to do more work getting the case for the first time, but I think it would increase the confidence that people have in the courts.
The case that David's talking about involved the New York Times. It was an opinion piece that was written, but in the opinion, exactly. You may say, well, aren't opinion pieces allowed to say what they want? Yes and no. They asserted, as David has suggested, that Sarah Palin was linked to that shooting of Gabby Giffords, and that is what was going on in that, again, that opinion piece that defamed Sarah Palin as saying her and did damages to her reputation. And that's what this is all about. I have one very weird sort of thing that came in from a listener. Let me see if I can just find it. Here it is. Before David goes, can you ask him where he got the little spinning globe in his desk?
I've gotten that question before. And at the American Museum of Natural History, I bought it retail because it helps that great museum in New York City. And that's where you can get one. You can probably order one if you go on. I have no financial interest in this. I try to never plug anything on your show. Except my pet theories about the legal system, those I do plug because this is a great forum to express what, based on 35 years of experience in the federal courts, I've come to think about some of these important questions.
Sure, of course. Good stuff. So it's the American Museum of Natural History. Is that what you said, in New York?
In New York City. And that's
love
where
it.
I got and they have a couple of different, they have one that's sort of the planet, the way it looks, not with the political geographic divisions, but just, the way it looks from space. They have that one
Sure.
too. I got that one for a good friend of mine.
That's terrific. Well, question asked and question answered. We'll see you tonight at the meetup, and I think we're going to be, I don't know when you're coming through. I forget. I think you did send me
Around
something.
7 p.m.
Around 7. Great. So we'll just be kind of maybe unpacking a little bit of what we've seen with the sit-down interview that Walz and Harris are doing with CNN. In any case, we love our time talking law, talking big cases, talking the future of the law in America with you. Thank you for spending some time with us on Thursdays. David Katz, everybody.
My
Thanks,
pleasure.
David. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.